these lights a little bit, so we have a little bit of lighting spread out here. So some proper lighting here. There we go. How's everybody doing? Happy Christmas, everybody. Happy Christmas. Happy to see you guys here. We should have a few people come on, but I'm going to go over the poster today. I'm going to go over in some pretty intricate detail, and what I'm going to be focusing on specifically and primarily, if you guys have not been to one of my live events before, I can't read the comments. I can catch them once in a while, but I can't really get into the comments because it'll distract me. And what I want to do is give you guys a full exhibit of how and when we lost our rights in this country, because you can trace the steps back if you just follow a timeline. Good to see you guys. I'm glad you guys are here. So we're going to go over, see the timeline here? We're going to go over the timeline of America and exactly when we lost our rights, how we lost our rights, and specific cases and acts and executive orders that stripped away your fundamental liberty of the Bill of Rights. And people don't understand this. They don't get it, right? And so when it comes to the Constitution and it comes to the Bill of Rights, there's nothing in the world that I'm more passionate about you not having your liberty. It makes me so, I don't want to get bunched up on Christmas here. But when we get into the facts of how you lost your rights, we're going to trace it back. How you doing, Dr. Sean? Nice to talk to you today a little bit. I had a little back and forth in the comment section with you. I appreciate your comments. And I will be passing the bar, the Act of 1871. Are you talking about the Buck Act of 1870? Which Act of 1871 are you talking about, Flip? Go ahead and send that to me if you would, please. I'm always open to hear new information and learn new information from you. And so now I'm used to going live on TikTok, but unfortunately, I don't go live on TikTok as much anymore. I'm going to focus more on YouTube because it's a little bit of a more refined crowd, a little bit more of a crowd who understands things. And so we're going to get up there. You guys do me a favor, hit your like button if you would, please. Try to get a few more people in the room. The crowds I had on TikTok was 10,000 people. I was the #1 live account on TikTok for several months because I taught the origins of law. It really doesn't have much to do with me as a person. I'm a little bit brash. I'm a little bit aggressive. And so I know that about myself. I make no apologies for it. However, it's the content. And so now I think we have 16 people in the room. That's enough for me to start. And so I'm going to begin here and now. And we're going to start with the Bill of Rights, all right? So we're going to go back here to the beginning. Now, if you're unfamiliar, you've never seen any of my lectures before, you talk about the Founding Fathers, but I talk about the Enlightenment thinkers who formed the Constitution, who formed the basic understanding and philosophy of the Bill of Rights, of our Constitution, because to me, that is far more important, that we understand the philosophy of how we got our Constitution, of how we got our Bill of Rights. That to me is the most important thing, because there's people here and now, and there's people within different groups, and I don't want to give anybody any credit here for something they don't deserve, but they'll say things like, oh, we're going to have a revolution and then we're going to rebuild this country. No, we're not. No, we're not. We are not going to a revolution. We are going to follow the philosophies of the Bill of Rights. We're going to follow the Constitution, and we're going to get on track here sooner or later, because now that we can all unite with social media, we are going to take our rights. Let me just say something real quick, and then I'm going to get into the philosophy of law, and then I'm going to get into specific acts and cases that fundamentally stripped your rights, that took your rights away from you. And it goes all the way back to the beginning. So let me just mention a couple things here really, really quickly, because I don't want to come back into the back of history, because we're going to end around 2010. That's the last legislation or Supreme Court case that I'm going to talk about. But let's just start off with this, okay? Now, James Madison and Thomas Jefferson, these two men here, they wrote the Bill of Rights, and they wrote back and forth in the Federalist Papers from 1863 until 1776. 13 years of sending letters back and forth in the Federalist Papers. If you haven't read the Federalist Papers, I highly recommend you do. I listened to them on YouTube and I read the book at the same time, and that's what helped me get through the Federalist Papers. It was a hard thing for me. It was a hard thing for anybody. If you want to understand the basis of our Constitution, you have to read the Federalist Papers. You have to read them. That's just the way it is. And you can listen to them on YouTube. There's several different teachers of the Federalist Papers on YouTube. I prefer the straight read version and then copying and then reading along on the book. So James Madison and Thomas Jefferson, the Bill of Rights, the documentation that they left wasn't for them. It was not for them. James Madison and Thomas Jefferson wrote a document for you and I to live up to. Now, of course, this was supposed to be lived up to by the people in the early 1800s and the mid 1800s, but of course, they didn't do it. They didn't do it. They didn't do it. They failed us. They failed us, they failed our children, they failed our grandchildren, and they failed America. And so that's why now with social media, we are finally united enough, there's enough of us together that we can make the Bill of Rights come true. So this is the only housekeeping thing I want to talk about, and then I'm going to go right into it, because these two gentlemen wrote documentations for us to live up to today. And it's very important you understand that. They were fatally flawed human beings. They both had slaves. They both had slave women. They both, I can go into great detail how flawed they were. But they were also, if you didn't know, Thomas Jefferson was a genius. James Madison was a genius. Jefferson wasn't quite as smart as James Madison, but James Madison, hey T-Roy, good to see you, brother. James Madison was literally a genius. Einstein level smart. 5'3", just a small little guy. Brilliant, absolutely brilliant. And the difference between them is they had differences, they had a disagreement on slaves, on black people. And the disagreement they had was that Thomas Jefferson believed that black people were inferior, their brains hadn't quite melted all together yet, they still had 2 grooves in the back of their head. You guys have all heard this story from Django Unchained. That's an actual true story that colonizers in the very beginning, colonialists, they believed that. They believed that with all their heart. James Madison, on the other hand, if you read Noah Feldman's book, I can't remember the name of the book, but the book is Letters between James Madison and Thomas Jefferson. James Madison said that no, black people are the same as us. They have the same brain, same emotion, feel pain, feel love their children, the whole thing, but they both had slaves. And so it fundamentally flaws them in a lot of ways, even though that was very normal for those times. As a matter of fact, if you were an elitist and you didn't have slaves, you couldn't be an elitist because you couldn't keep up with the other people who were using slave labor to build their wealth. It just couldn't be done. And so this is the beginning of understanding that the founding fathers of our country were fatally flawed, and at the same time, they were a product of their environment. Now, if you go along the top of the poster here, all of these are the Supreme Courts. These are all the different Supreme Courts throughout the history of time. Now, I've studied every single Supreme Court justice that there is. There's been 115 Supreme Court justices. I've studied all of them. Now, I don't remember every single detail about all of them, but I can tell you this. There's been a few. John Harlan back here, and then up here, William O. Douglas here. And these people, William O. Douglas, for example, he was the lone dissenter in Terry versus Ohio. However, when you read all of his decisions, there are several decisions that William O. Douglas did that you would not agree with today, that would make you very unhappy. However, William O. Douglas dissented in Terry v. Ohio. I'm jumping ahead a little bit. I just wanted to show you guys the important fact is that each one of these Supreme Courts, each one of these, right? The beginning courts were full of white supremacy. If you don't like to hear that, that's absolutely the truth. So now, let's get into the exact specifics of when and how we lost our rights. We're going to start with the philosophy of the Constitution, the philosophy of the Bill of Rights, and then we're going to get into very specific acts and executive orders and legislation that completely stripped you of your rights. And if you guys have seen my last couple videos, all I know is what I know, and I don't know anything else. So that's, you see what I'm saying? I'm just going to share with you guys what I know, and then you guys can, all I want to do is overturn Terry versus Ohio. That's the most important thing to me in my world, in my life, and Terry will fall in my lifetime. Making the Supreme Court electable is going to be up to one of your children who's watching this video now. I don't curse. I'm not going to use any bad language. You might see me get excited a couple times. I'm a human being. I'm very passionate about this. Okay, so now, when we talk about the Bill of Rights, and you talk about the first 10 civil liberties, these are founded on what? What are the first 10 civil liberties founded upon? They're founded on Lockean theory. Upon the theory of natural law written by John Locke, 1632 to 1704. John Locke is going to write the theory of natural law, which is going to say that every person is entitled to life, liberty, and property. Liberty being far-reaching. Liberty being the most important element of his entire study of Lockean theory, every single thing that he talks about. If you put John Locke into Google and you say, what was John Locke, what was he known for besides divine morality, which is a religious thing, kind of, but it also ties into our Constitution. John Locke's theory of natural law is based on the very first principle of liberty, that you have liberty, you are free. And why is that? Because John Locke's born in 1632. What's going on in 1632? We have monarchs, we have kings, we have royalty, we have princes, we have people who they take precedent, their life takes precedent over your life. And so, you ever heard all men are created equal? That doesn't come from the Constitution. That comes from John Locke. John Locke wrote that all men were created equal. That doesn't come from Madison or Thomas Jefferson. That comes directly from John Locke. And so now understand that the Bill of Rights and the Constitution is based on Lockean theory. That you have the same right, and this goes into the Kyle Rittenhouse trial. So now you understand this. I'm not going to get lost on different tangents here. I want to go into specifically of when and how your rights were stripped from you. So if I have a right to life and I have a right to liberty, then when does that change? When my right to liberty is then segregated by law. Do you understand what I'm saying to you? So when I'm separated from me having the right to be free, then I've lost my liberty. If I can be subjected to a police state, authoritarian prison state, then I have lost my right to liberty. If I have to watch what I'm going to say, if I have to watch my actions, even though I'm not going to create a victim, then I have lost my right to liberty. So the second part of our Constitution, our Bill of Rights, is based on Jean-Jacques Rousseau. Jean-Jacques Rousseau wrote The Social Contract. If you have not read The Social Contract, it is not a difficult read. And by the way, you can listen to it on YouTube for free. You don't even have to buy it. So now, John Locke's theory of natural law says that all men are entitled to life, liberty, and property. Jean-Jacques Rousseau's theory, along with Thomas Hobbes' theory of the social contract, they lived at different times. Hobbes lived, I think, 80 years before Jean-Jacques Rousseau. And what the social contract says is that even though we're all entitled to life, liberty, and property, according to Thomas Hobbes, I believe it's called Bellium omnis contra. Bellium contra omnius omnium. I can't speak Latin or French. So now what's going to happen here is that what that means is a war of all against all. So your social contract written by Thomas Hobbes and Jean-Jacques Rousseau, what this says is that even though we're all entitled to life, liberty, and property, unless we all collude, all free men collude together to live under a social contract that we all agree to live under the same laws, then we're going to have an absolute tyrannical state. And it's bellium omnia contra omnis. That's what it is. Bellium omnium contra omnis. And what that actually means is a war of all against all. Because if we all just go by the theory of natural law, that I have the same right to life than you do, well then all I'll do is challenge you, kill you, and take all your stuff. Because hey, if we all have the same right to life, I'm going to challenge you. And so the theory of natural law on its own, without the social contract being over the top of it, then you have a bellium omnium contra omnis, a war of all against all. And Thomas Hobbes, his view of men, if you read Leviathan is also available on YouTube to listen to for free. So you'll be able to get a basis and understanding of what our Constitution and what our Bill of Rights is based upon if you only study these men here. And then Montesquieu's Spirit of Laws. Once again, Spirit of Laws is available on YouTube. You can listen to it. And when you go and see how many views are on these videos that teach you the fundamentals of life, it is just embarrassing. It is truly an embarrassment. It really is, because so few people take the time to listen to them. And even if you don't understand it, the more information you put in your brain is a supercomputer. It'll put it together for you. So now we have natural law, we have the social contract, and then Montesquieu's Spirit of Laws, which creates checks and balances. Now this is the foundation of our Constitution. It is not our founding fathers. Because remember, the Spirit of Laws is going to be published in French in 1750, published in English in 1752. And what that's going to do is that's going to set the basis for Thomas Jefferson and James Madison. They're literally going to plagiarize large parts of Montesquieu's writings because they're going to create. Have you ever heard the saying by James Madison, you must have men's ambition to counter men's ambition? That comes directly from Montesquieu's book, The Spirit of Laws. The Spirit of Laws is quoted both in the Federalist Papers and the Anti-Federalist Papers. So if you haven't read the Anti-Federalist Papers, guess what? They're available on YouTube for free. I know I sound like a broken record, but you think it was easy for me? It was hard. I had to research and read all this stuff. I'm challenging you to join me. Join me in educating yourself. Stop hiring lawyers. They suck. Lawyers only care about your money. They don't have a principle of freedom and liberty and nationality, that we are a nation of laws living, governed together to freedom. They don't have that. A lot of guys who become lawyers, a lot of women who become lawyers, they're mercenaries. They want to make money off of you. That's what they want. They want you to pay them. And they're thinking about, oh, I really want to help John's case, but I got my kid's recital next week and I want to have that wrapped up before I go to Bermuda. They're not thinking about, oh man, this is John's whole life in a nutshell here. That's why I've learned all these things so that I can be my own lawyer. I'll take the bar next year in California, and then I'm going to take the bar in several other states, as I talked to Dr. Sean Berry earlier today. So now we have these fundamental principles, and then what happens is we're going to get the Bill of Rights that's going to be created through the Federalist Papers that are written from 1763 until 1776. And so you're going to get these first 10 civil liberties that are going to go with the Constitution, and that's going to happen in 1776, and then it's going to be ratified into the Constitution in 1791. Now, why does that matter? Why does that matter so much? It matters because without the Bill of Rights, we would have been overrun long before now. We are absolutely being overrun now, and that's because of Terry versus Ohio, but I'm going to get into that in a moment. I want to go into step by step of how these people bastardized America and America's true philosophy of freedom based on Montesquieu, Jean-Jacques Rousseau, and John Locke's theory of natural law. So now right here, what's going to happen? The very first case is going to be Marbury versus Madison. Marbury versus Madison is where the federal government, and we're going to just a real quick synopsis here, real quick overview. Now, you know what the executive is, that's the president, you know what the Congress is, and you know what the judiciary is, the three branches of government. Now, the judiciary didn't have very much power. What it was supposed to do is not what it does today. And in Marbury versus Madison, this is when John Adams is leaving office, and he's a Federalist. And so what he does is he sends John Adams out to appoint a bunch of new federal judges. And this is the very first step. Now, Marbury versus Madison is largely quoted as being for what's called judicial review. And judicial review is a very important part, a very important essence of America. However, it's ruined our country today because let me explain to you exactly what I'm talking about. When you say, how did we lose our rights in Marbury versus Madison? We gave all of the power to unelected Supreme Court personnel. You notice I don't call them justices because they're not. They're absolute horrid nightmares. And here's the reason why. John Jay, the very first, I think he was the second Supreme, the John Jay Court from 1789 to 1900, John Jay in Federalist number 3 is going to write, if we appoint the right men in the right places. I believe it's, I listened to the Federalist Papers as I read along in the book, and in Federalist number 3, I believe it's 6 minutes in. If you go to the Federalist Papers on YouTube, 6 minutes in to Federalist Paper number 3, John Jay, someone's reading the letter that he wrote. It's a compilation of letters sent back and forth between the Founding Fathers. And John Jay writes, if you appoint the right men in the right places. Well, what does that mean exactly? You know exactly what that means. That means if we consolidate power at the top to the most elitists, that will continue to control this country as though we are kings. And that's exactly what's happening now. That's exactly what's happening. And so in Marbury versus Madison, here's what happens specifically. Judicial review is established. Meaning, let me explain. When we vote for Congress, Congress writes laws. Then what the executive does is sign laws into effect. These are the first three branches of government: Article 1, Article 2, Article 3 in the Constitution. When you hear Article 1, Section 2, they're talking about the Congress second article of the second paragraph of Article 1. Article 2 is the executive, Article 3 is the federal. And so Congress writes laws, the executive signs them, and then the judiciary, the federal judiciary, in Marbury versus Madison, they have a right to review the law to see if it goes against the Bill of Rights or the Constitution. That's what judicial review actually is. Now, in principle, that sounds amazing. So in other words, we vote for Congress, so the people we vote for write a law, then they submit it to the executive, and then the Supreme Court is going to check to make sure that the Congress wrote a law and the executive signed a law that's going to pass the muster of the Bill of Rights. But that's not how it's gone. That's not how it's gone. It's been absolute tyranny. And why? Because we've appointed the wrong men in the wrong places. That's why. That's exactly why. This is the first place we lost our rights and we can't go back. If you listen to Anthony Scalia's interviews on YouTube, which I've listened to every single interview he's ever done. I'm talking 30, 40 hours of listening to Anthony Scalia interviews because he's not, a lot of people mistake what Scalia was. They say he was a constitutionalist. He calls himself a textualist, meaning that that they had in common law, the death sentence, that they had in common law, they didn't have any laws against children working, doing child labor. And so Anthony Scalia calls himself a textualist. Anthony Scalia, as a conservative, failed us miserably time and time and time again. Now, I'll go into that later as soon as we get into Scalia's reign on the Supreme Court, but he absolutely failed us. He failed the people. And it's an embarrassment when I show you exactly how he contributed and added to the police state, prison state, using his own personal bias against marijuana in the 2005 case of Gonzalez versus Reich, R-A-I-C-H, Gonzalez, Attorney General Alberto Gonzalez for George Bush. So now as we continue down, so Marbury versus Madison is where the judiciary takes a giant piece of the pie and says that we'll be the arbitrators of what we consider to be just or unjust. And who are these people? Appointed men. Appointed. Anybody here appointed to their job? Anybody here appointed? Just go ahead and type right here if you're appointed. Just write right here. Anybody appointed to their job for life? Go ahead. Are you appointed? I'm reading the comments real quick. Is anybody not appointed to their job? Just let me know in the comment right here. Say I'm not appointed to my job if you're not appointed to your job. Especially a job for life that pays you tons and tons of money and you never have to worry about money and you never will be fired. Throughout the history of time of the 115 Supreme Court personnel, 0 have been impeached. Absolutely 0. Meaning, when they're appointed for life, they're appointed to life forever over you and me. Your children, my grandchildren, will never get a slice of freedom because these men have been appointed for life. Now, we appointed governors, we appointed people to the Senate until the 17th Amendment. We appointed people to the Senate in Congress until the year 1913 with the 17th Amendment. So then let me ask you a question. Why did we change it? According to the Constitution, it says that we will appoint senators. The House of Representatives, who we vote for, will then appoint a senator. Well, what happened? Can you imagine just for a moment, senators who were appointed were corrupted? And then they worked with the Supreme Court during the Lochner era from 1897 until 1937. This is called the Lochner era of court from 1897 to 1937. And when the senators colluded with the Supreme Court, it created a business monopoly across several different corporations, including a little company called Standard Oil. You ever heard of that one? By a guy named J.D. Rockefeller? You ever heard that before? You ever heard of Standard Oil? Yeah. The reason why we elect senators is because of Standard Oil. I can go long into detail about it, but I'm not going to get long in the tooth on this specific subject because I'm going to move right along. So now right here, so the judiciary takes all the power. And so then right here in 1850, you have the Fugitive Slave Act. Do I have it on here? I think I have it on the poster. Let me see if I have it on the poster. The Fugitive Slave Act. And why do I say that the Fugitive Slave Act, is going to strip you of your fundamental liberty based under federal law? Why would I say that? Can anybody take a guess? Why would I say that the 1850 Fugitive Slave Act is going to fundamentally strip the liberty from Americans? Why would I say that? How come? Anybody take a guess? Just take a guess why I would say that. Because the United States in 1850 has been cut in half. And remember, we've only taken over and colonized this second half of the United States. Over the 1850, 1860, we're going to take over California and Mexico and Texas. We're going to take those states. but really it's the middle of nowhere. It's barren, it's nothing, right? So then over here is where America actually is, and above this line right here, you're free if you're a person of color, and below the line, you're not free. And so when they passed the 1850 Fugitive Slave Act, I'm skipping a lot of stuff here because I can't get everything. I only stay on for 1 hour. So after 1 hour, I'll take a few questions, but then I will start to take a couple questions. I'll start to drip it down at about an hour. So the 1850 Fugitive Slave Act, it's a federal act, and this act is written by Congress. Now, what's the big problem? What's the number one problem we have when we create the United States of America's Congress with 2 senators? What's the number one problem we have? Misrepresentation of population. Because right here, the North far outnumbers the South. But the way the Constitution is set up, it's set up so that the slave states get the same amount of representation as the free states. That's why you have 2 senators in every state. That's why today in Alaska, you have 2 senators, and in California, you have 2 senators. You got 500,000 people in Alaska, and you got 30 million people in California. And so they set it up that way so that slave states would have the same amount of power as the northern states, which dramatically outnumbered them. And so the 1850 Fugitive Slave Act, let's just put a random number so we can understand the numbers here. In 1850, let's say there's 1 million people in the North, and there's 250,000 people in the South, which those are not correct numbers, but I'm not a mathematician here. So 250,000 people down in the South, 1 million people in the North. And the Fugitive Slave Act of 1850 says that you have to, if a black person gets free and comes to the North, you have to send that person back down to hell, where they're going to be tortured. They're probably going to be hurt. They could be lynched. And so the 1850 Fugitive Slave Act, that's the first that's a major jab against Americans. Now, I'm skipping a lot of stuff here, but I just want to get the real fine points. Because remember, the 1850 Fugitive Slave Act is one thing, but then the 1852 book of Uncle Tom's Cabin by Harriet Beecher Stowe, if you haven't read that, I highly recommend that you take a look at it. You know, I didn't check to see if Uncle Tom's Cabin was available on YouTube because I read the book. But if you actually want to take a look, if anybody wants to let me know if Uncle Tom's Cabin is available on YouTube, I would absolutely listen to that again because it is a riveting book. So the 1850 Fugitive Slave Act, what that does is makes it so that if a black person escapes, you have to take them back down to the South, knowing what will happen to that human being. And that goes against what? Natural law. That goes against natural law. That every man has a right to life, liberty, and property. Well, if you're taking someone who's gotten to the North and the North has freedom, and then you have to take them back down to the South into slavery, you're going against natural law. You're going against the fundamental freedoms that America promises to uphold. And so Americans are pissed. Americans in the North, remember 3-1, there's 3-1 Northerners than there are to Southerners, and we have the same amount of representation. And so the Northerners are absolutely pissed. Number one, a lot of them know what's going on, but it's not like it is today. I don't travel over to Pennsylvania and then cruise over to Richmond and then head on down to Harper's Ferry. No, that's not how it goes. You don't just travel around. Someone just said Uncle Tom's Cabin is available on YouTube and it's free because it's public domain because it was published in 1852. If you have not listened to that book or read that book, you're not going to understand what I'm actually saying. Because 1850, the Fugitive Slave Act is one thing. 1852, Harriet Beecher Stowe's book, Uncle Tom's Cabin, then gives Northerners the resolve to be willing to fight. The resolve to say, oh my freaking Lord, this is what's going on down there? I am willing to fight and die because that goes against the philosophy of natural law. That goes against the philosophy of Jean-Jacques Rousseau's social contract. This is important stuff. Americans are stabbed in the back with the 1850 Fugitive Slave Act. By 1852, when Harriet Beecher Stowe's book comes out, the Northerners are ready to kill. Really. And so then when is the next big betrayal? So for 5 years, Northerners have to send black slaves who have ran away to get to freedom, where they're promised freedom in the North, where they're promised the same promise of natural law that you and I get, and instead they have to send them back down to be murdered. And you know what's going to happen, especially after you read Harriet Beecher Stowe's book. And so then what happens? 1857, the Dred Scott case. The Dred Scott case is what starts the Civil War. If you didn't know that, now you know. The 1857 case of Dred Scott, everybody knows what it is. Everybody knows what it is. If you don't know what it is, type it right down there. Type it right down there. If you notice, and someone just said that the best way to teach your children, the reason why I no longer curse is so that you can sit your children down and you can show them this video. And it took me a long time to quit cursing. It took me a long time, but I will not do it because there's a bigger purpose in life, and that is to educate the youth, because we need you kids, 10, 11, 12, 13 years old. It has to be you. I'm going to be dead before it happens. It has to be you children that make the Supreme Court electable. We do not want to appoint the right men in the right places ever again. This has to be changed. And it's up to you children to change it. So I'm willing to change my language for you. So 1857, the Dred Scott case comes, and everybody knows what that is, right? Everybody knows the Dred Scott case. If you don't know what the Dred Scott case is, please tell me here so I don't have to go into a long lecture. Dred Scott is where they rule the unelected Roger Taney court here from 1836 to 1864, which, by the way, all white supremacists. Every man on the Supreme Court is a white supremacist. Now, I don't love saying that because if you didn't know, a bunch of black people just deplatformed me. A small group of black people. It's not all black people. A few black people deplatformed me because they were jealous that I was the fastest rising TikTok in America. They were very jealous. And they didn't want a white person who's Colombian leading on civil liberties. I don't want to get in a long lecture about this. So, Dred Scott, they say that the Roger Taney court says that Dred Scott's not a man, he's property. Well, that goes against the fundamental teachings of natural law. Okay? That goes against the fundamental teachings of natural law that all men are entitled to life, liberty, and property. This ruling, the Dred Scott ruling of 1857, that drives John Brown crazy. He literally goes nuts. This guy right here. He goes nuts. When the Dred Scott ruling happens, he loses his mind. He loses his mind. And by 1859, he's born in 1800. By 1859, he is so mad that he tells his best friend, Frederick Douglass, hey, listen, here's what I'm going to do. I'm going to head over to Virginia to Harper's Ferry, and I'm going to take down the Virginia Armory. I'm going to take all the weapons out of the Virginia Armory, and I'm going to free all the slaves. That's what John Brown says. And Frederick Douglass says, I'm not going with you. Frederick Douglass wrote a poem that I memorized. I memorized it a few years ago. I don't know if I'm going to remember. I don't have it word for word right this moment. But John Brown says, when Frederick Douglass read the eulogy for John Brown after he was hung in Harper's Ferry, and when they took him to hang him, he did not weep. They locked him up in a dungeon for a month in Harper's Ferry. General Lee did, because they killed his son, they killed his group of cohorts, and then they locked him in a dungeon for a month because the North and the South were teetering on a massive war. And of course, the South really didn't want to go to war with the North. They just wanted to have slaves and run slavery. And so the Northerners, after Harriet Beecher Stowe's book, were like, no, we're done with slavery. And so the North had actually kind of segregated away from the South. But the problem wasn't just John Brown attacking Harper's Ferry. It was Southerners who were attacking Northerners. The Southerners were annoyed with Northerners, and so they were attacking people in the North on the border. And so when John Brown goes there, he spends a month in jail, and what he does for a month is he writes letters to all of the leaders in the North, including Susan B. Anthony, including Elizabeth Cady Stanton, including Isaac Hopper. And this is who he's writing letters to. He's using his right to petition. As you know, in the first 5 big liberties, you have the right to petition. And so what he's doing, he's in prison in 1859, and so he's sending letters to James Buchanan. James Buchanan is president at that time. And so he's petitioning James Buchanan to pardon him and get his freedom back. James Buchanan does not. Of course he doesn't. And so what happens is they bring him to the gallows to hang him. He doesn't cry. He doesn't weep. Instead, he says, fight for your freedom, fight for your lives. I believe he's executed in December of 1859, and the Northerners are pissed. The Northerners are furious. As a matter of fact, Harriet Tubman then makes an announcement through the Underground Railroad that John Brown has been slain. Oh, and this gets me upset. I gotta make sure I calm down here. Okay. And so then William Lloyd Garrison, right here, this gentleman here, he does a publication. He writes a publication called the Liberator magazine, the Liberator newspaper, and this is widely known as the very first black newspaper. And so when the Liberator comes out, that William Lloyd Garrison writes that John Brown has been slain, and he quotes Harriet Tubman, all slaves stop working and they weep. If that doesn't get you, then you know what? You don't really feel what the pain and struggle of our country. Because you had a bunch of people who were enslaved under whips and chains. And instead of them working, when they find out that John Brown has been killed, they stop working, throw down their work, and say, we're not doing anything for a minute. Right? And this is led by William Lloyd Garrison and Harriet Tubman. And so the big problem I'm having right now with some members of the Black community, not all members, but some members, is this idea of Black supremacy. We can do it all on our own. We don't need your help. You know, they tried to call me an ally and accomplice. I rejected it. I'm not your ally. I'm not your accomplice. I'm an American. There's no such thing as a Black History Month. There's such thing as American history, and you're a part of it, and I'm a part of it. When they started to call me an ally, I said, I'm not your ally. I didn't do this for you. I did this because I was no-knock raided by the chief of police in LA in 2002. That began my constitutional study, and I've never stopped. So now, 1859, when John Brown is hung in the gallows at Harper's Ferry, that is a big, huge violation of what? Natural law, of the separation of powers, of the social contract. And Americans in the North are pissed. They are pissed. They are absolutely furious. And so now what happens here is in 1861, the Civil War begins, and it's going to continue until 1865. 1865, you're going to get the 13th, 14th, and 15th Amendment from 1865 until 1870. The 13th Amendment that says slavery is abolished unless, of course, you're arrested, then you're going to be a slave again. The 14th Amendment says in 1868, says you're going to get equal protection under the law. And then the 15th Amendment is going to give Black men over the age of 21 the right to vote in elections. This is the beginning of Jim Crow laws. Now, I teach this all the time. I'm going to do a very quick synopsis of it because I want to go right into the next betrayal, which is going to be Cruikshank versus the United States, where Americans feel completely and utterly betrayed. So now from the 13th, 14th, and 15th Amendment, from 1865 until 1870, there was a famous actor named Dartmouth Rice who painted his face black, his hands black, and he acted as though he was a feeble-minded slave. He wore dirty clothes, his fingernails were dirty, he couldn't walk, he couldn't talk, he couldn't drink, he couldn't function. And he went by the name Jim Crow. He did the Jim Crow Act from 1835 until 1860. He did the Jim Crow Act. The Civil War begins in 1860, so he started the Jim Crow Act in 1830. It ended in 1860, 1 year before the Civil War, after John Brown was hung. And so then what they said in the 13th Amendment is you're going to free Jim Crow. The 14th Amendment, you're going to give equal protection under the law to Jim Crow. And the 15th Amendment, this is where the phrase you're calling Black people Jim Crow really solidifies and isolates. Is with the 15th Amendment, Northerners and Southerners, because Northerners weren't in love with Black people either. Abraham Lincoln was not the great emancipator, he was the great politician. However, he had the tenacity and the wherewithal to say, if you do not listen to me, I will kill you. And then he did. And then he went to the South and he killed them. And so that's how we abolished slavery. But then the Jim Crow reference of a feeble-minded person, a feeble-minded Black person being a slave, really solidifies with the 15th Amendment when Black men over the age of 21 are going to get the right to vote. And so Northerners and Southerners, mostly Southerners, are going to say that, hey, you can't let Jim Crow vote in our elections. And then, of course, that's going to go into Plessy versus Ferguson in 1896. They're going to call Jim Crow laws, which is going to create Black codes, which is going to be another. But let's not skip any steps here. So Susan B. Anthony gives up her mission to get women's suffrage passed, to get women the right to vote. She's going to die in 1906. 1908, and then women aren't going to get the right to vote until the 19th Amendment with 1920. So she's going to miss her window to see women get the right to vote because now she collects 400,000 signatures to abolish slavery. 400,000. You try collecting 400,000 signatures today. Go ahead, try. I dare you. You collect 400,000 signatures. I tried to collect signatures to make it so that police couldn't shoot dogs anymore. I didn't get anywhere, and that was when I had 300,000 followers on TikTok. I couldn't get anywhere. to get people to sign a petition that banned cops from shooting dogs. She collected 400,000 signatures on parched paper. Okay, that's a big one. That's a big one. So then as we go down the line here, so now what's going to happen here is the 1873 slaughterhouse cases. The 1870, now Americans are going to feel, Americans are going to feel fundamentally betrayed by the 1873 slaughterhouse cases, and this is in Louisiana. This is Slaughterhouse Company versus the Slaughterhouse Butchers Association. So in other words, the state of Louisiana is going to give a monopoly to one particular slaughterhouse in Louisiana. Now, the slaughterhouse case of 1873, what the Slaughterhouse Company is going to do is they're going to use the 14th Amendment, equal protection under the law. They're going to use the 14th Amendment and they're going to say, hey, we have a right to contract with employees. You wrote the 14th Amendment, which was originally intended so that black people would get the same representation under the law as people who were not black people, who were free already. The same representation, meaning the same protection, the social contract, that we agree to be governed under a set of laws as long as we get the same rule of law for all of us. Okay? And so now right here, what's going to happen, the 1873 slaughterhouse cases, I just got a real quick blurb here. This goes against everybody, not just black people. This wasn't just slavery. This was against all people, where the Slaughterhouse Company says, we're going to give you a contract to work, but you're going to work 13 hours a day, 7 days a week. It's just another form of slavery. And we're going to use equal protection under the law. We have a right to contract and be contracted with any other person. We're a company. We're just going to contract. And so Americans, their rights are completely and fundamentally stripped, and this is going to start the entire court system from 1897 to 1937, called the Lochner era, and that's based on a 1905 case called Lochner versus New York. And I'll let you guys read the Lochner case on your own. I'm going to go over in a second. So the slaughterhouse cases, what this does is it allows big businesses to have monopoly over your work life. You can get a job at the slaughterhouse company in Louisiana, the only slaughterhouse company that's going to get state contracts, but you're going to sign a contract to work there where you're going to work 80 or 90 hours a week. Americans are betrayed. You lost your rights. Right there. Americans are betrayed. And so then, here's what's going to happen next. So then right here, the 1876 case of Cruikshank, this is going to fundamentally strip all of your rights. And the Cruikshank case says specifically, and the 1876 Cruikshank case is going to be from the Waite Court. I believe, what's his name again? I can't get his first name in my head for some reason. The John Waite Court, anyway. So what they say in the Cruikshank case right here of 1876 is that the federal government cannot ensure your civil liberties. We can't guarantee your civil liberties. That's what the case of Cruikshank says. Now that's not against black people, that's against all people. If your civil liberties cannot be upheld, then you don't have the right to life. You don't have the right to liberty. You don't have the Second Amendment right. You don't have a right to a speedy trial. You don't have a right to cruel or unusual punishment being banned. You don't have a right to be free in your person, houses, papers, and effects. And that's from the Cruikshank case of 1876. That fundamentally strips all of our rights. Everybody's rights, not just black people. And that's why I say there's no such thing as black history in America. There's American history, and that's the only history we got. Because the 1876 Cruikshank case, whether you like it or not, that's what kicked off the lynching graph. And that's why in 1883, Pace versus Alabama, it bans interracial relationships. But then in 1884, you got 160 white people being lynched. And that's a combination of Cruikshank and Pace versus Alabama. Americans are fundamentally betrayed by the Cruikshank case, and you lose all your rights. As a matter of fact, the Cruikshank case of 1876, just so you know, isn't overruled until the 1964 Civil Rights Act. Until the 1964 Civil Rights Act. Do you understand that? So when these bunch of tyrants create unconstitutional laws, unconstitutional policies that are created at the Supreme Court bench, then we lose our rights for 50, 60, 70, 100 years. That's why we have to elect the Supreme Court. That's why I changed my language so that you'll show this lecture to your children. Because if you're a child, if you're a young person, 10, 11, 12, 14 years old, and you're watching this, we need you to make the Supreme Court electable. It's up to you. Take the ball, make it happen. I beg you, please. So now, right here, the Cruikshank case, that fundamentally strips your rights, and so Pace versus Alabama criminalizes relationship status. You can't have a relationship with another person. You're best friends with that Mexican worker, you die. Or you know what happens? The town alienates you and you can't get work anymore because you're hanging out with a Mexican guy. And he's just your buddy, but sorry, interracial relationships are banned, whether that be romantic or personal. And this is going to continue forward. So then here's the next one. It's going to be Cynic versus the United States. The 1919 case of Cynic versus the United States. Has anybody heard of this case before? Has anybody heard of Cynic versus... It's a very funny spelling. It's S-C-H-E-N-C-K, Cynic. His name is Charles Cynic. Has anybody ever heard of the Cynic versus United States case before? Just let me know right there. Just type it right down in there. Does anybody know the case? Can you guys just type it down there for me real quick? I'll read some comments real quick. I just want to know, has anybody read the Cynic case before? And do you know exactly what I'm talking about when I say Cynic versus the United States? Do you understand what happens here? You lose your First Amendment right. And I'll tell you what, it makes me so angry. It makes me, I get goosebumps up and down my arms because it makes me so God blessed angry when I understand the Cynic case. It makes me so pissed off. You can't even understand how mad it makes me. I can't even, okay, so Charles Cynic and his wife, Elizabeth Bayer, B-A-E-R. So remember, you've got World War I going from 1914 to 1918. Now, maybe you guys have all seen that movie made by the director, the World War I movie that was just incredible, that it shows the battle of, it doesn't matter. So it does matter, actually. I don't mean to say it doesn't matter. It does matter. One of the best movies ever made of war. And it shows the actual battle of what happened. And so now Cynic is arrested in 1917 when there's a draft going on. Charles Cynic is. And Charles Cynic is arrested for handing out pamphlets to people standing in line to the draft, knowing that if you go over to World War I, there's a very high probability you're going to die. You will die. You're 18 years old, and Charles Cynic sees these guys standing in line to go to the draft, 1817, and they're going to go to war, and he knows that at least 60-70% of those young men standing in line will die. And so him and his wife, they create pamphlets that say slavery's been abolished. You do not have to go to war. The draft is not a law. It's a mandate. You don't have to go enforce. What's the exact saying on the pamphlets? It was invoke your rights. You don't have to go to war. Slavery has been abolished. Now, have you all heard the saying, you can't scream fire in a busy movie theater? Who's heard that before? Has anybody heard that before? If you've ever heard that before, then you know exactly what I'm saying. Because what does that say? The First Amendment, your First Amendment right to free speech is limited. You can't scream fire in a busy movie theater. Charles Cynic was white. His wife was white. They were arrested under the 1897 Espionage Act that said that if you speak out against America, the 1787 Espionage Act, the 1897 Espionage Act, because what that says is you're talking against the American government. And so they arrest him under espionage. Now, here's the most ironic part when you really study the case and you really get into the minutia of understanding the Cynic case. Because when I found out that you can't scream fire in a busy movie theater, it's a quote by Oliver Wendell Holmes, who's going to say you can't scream fire in a busy movie theater. Oliver Wendell Holmes, who was on the White Court from 1910 Oliver Wendell Holmes was on the court from 1900 to 1930. So, but the White Court, the Douglas White Court, when Oliver Wendell Holmes was on that court, he had written the decision and written the quote, you can't scream fire in a busy movie theater, for a case previously. He had written this beautiful dissenting opinion in another case that was really for government power and colluding government power to the top. And so Oliver Wendell Holmes had written this, you can't scream fire in a busy movie theater. And Douglas White, what he says is he goes, oh man, he goes, Oliver, that's a really great thing you wrote. Let's save it for another case. And so they collude together with the president. And you're going to go here. Here. Warren G. Harding, Woodrow Wilson right here. Woodrow Wilson is president from 1913 to 1921. So Woodrow Wilson is going to preside over what? World War I. Woodrow Wilson is a wartime president. Woodrow Wilson is no moron. He's a very smart guy, in case you didn't know. Woodrow Wilson was sharp as a tack. People may give Woodrow Wilson a lot of shit because he was a pro-slavery and was racist, but Woodrow Wilson was actually very intelligent. As a matter of fact, when they wrote to go pass prohibition, the Volstead Act in 1919, Woodrow Wilson vetoed it and said, no, we're not going to do that. And then Congress, the people we vote for, they overrode that. And so what happens is Oliver Wendell Holmes has written this thing. And so when Charles Sinnock's case is heard before the Supreme Court in 1917 or 1918 and then decided in 1919, the Supreme Court upholds his conviction of simply handing out pamphlets that say, assert your rights, do not go to war, slavery's been abolished. And then the saying of your First Amendment right is limited, you can't scream fire in a busy movie theater, that's what's printed in all the papers. That's what the newspapers print. And guess who prints it? J.D. Rockefeller and Andrew Carnegie. And why do they do it? For their monopoly on hemp, to make sure that hemp will be banned internationally. Because Standard Oil was broken up in 1911, but however, John D. Rockefeller is still chairman of the board. And guess who's selling all the newspapers? William Randolph Hearst. And William Randolph Hearst has been invested by Andrew Mellon. He's the Secretary of Treasury. Secretary of Treasury, meaning that Harry Anslinger is going to marry his daughter. So it's all based on big capital. It's got nothing to do with your First Amendment right being limited. You can't scream fire in a busy movie theater. It's about these men having all the power, having all the money for them. These men, we'd be better off if they were never born. So now this is a gigantic betrayal of American standards of liberty and freedom because your First Amendment right is not limited. If you scream fire in a busy movie theater, that's not a limitation of your First Amendment. That's disturbing the peace or inciting a riot. That's a crime. That's not a limitation on your First Amendment right. There's a very big difference here. And we together have to fundamentally understand that. So I'm going to take a step back right here because we're going to go into the 1911 Sullivan Act. This is where your gun rights are infringed upon, and who they infringe upon? By a conservative. By Governor Tim Sullivan of New York, who's a conservative. I believe he's a Democratic conservative. Someone find that out for me. I can't remember. Tim Sullivan, governor of New York in 1911. Was he a Democrat or was he a Republican? I can't remember. But Tim Sullivan, so if you haven't followed my lectures before, or listened to anything that I've taught before, the reason why we have a lynching graph in America, why it starts back here in 1892 and it doesn't end until 1965, is because of the Cruikshank holding, where the supreme tyrannists say that your rights cannot be enforced by the federal government. And as soon as the southern states find out that your rights can't be enforced, the lynching graph begins. And so in 1911 here, people of color and people who are poor, who are being marginalized, killed, lynched in rural America are moving into the city. And so Tim Sullivan, anybody know the answer on that? Was he a Democrat or was he a Republican? He was governor of New York in 1911. Was he a Democrat or was he a Republican? I know he was a conservative. And so Tim Sullivan, what he does, it makes sense that he would be a Democrat because Democrats in 1911 were the founders of the KKK. And so Tim Sullivan is going to fundamentally strip what? He's going to strip your Second Amendment right to self-protection. Who strips the rights of guns? Conservatives. Throughout the history of time, conservatives. Who's the last two presidents? Trump banned bump stocks. Reagan created the Brady Bill. Who's the Supreme Court justices that take away your liberty? The 1939 case of United States versus Miller. Who led on that? Conservative judges who took away your Second Amendment right completely based on the 1929 St. Valentine's Day massacre that was led by who? By the police. You see, it's all a great big forget you. Go have a ham sandwich. So, the Second Amendment that we have, the right to self-protection, the very first major infringement of that is the 1911 Sullivan Act, where if you want to carry a gun in New York City because all of the poor and all of the black are moving into the cities, And so the 1911 Sullivan Act, it's going to say that if you want to carry a gun, you have to get your right to carry a gun from the president of the police bureau. Does that sound familiar? Is that the current law today? Yes, it is. The current law today is that you have to get your concealed handgun license from the police. Why? Do you trust those guys? Because I don't. Do you think they're going to give me a concealed handgun license? No, they're not. Why? Because I don't like them. Because they're the tyranny, they're the fear, they're the darkness. When I drive down the road tonight, I'm not afraid of gangbangers. I'm not afraid of some of these people who said they're going to air me out. I'm not afraid of those guys, not one bit. Who do I fear? The police, who have a monopoly on power. And the 1911 Sullivan Act is valid today. If you want to get a concealed handgun license in California, I have to become a reserve sheriff's deputy. I wouldn't sign up to that if you were the last person on earth and I needed to sign up to you to drink water. I would not sign up to be an LA sheriff's deputy or reserve deputy so I can carry a handgun in LA. And that is the current law today. Does anybody here have a concealed carry license? And why don't you? Because you have to get your license from the president of the police bureau today. And that's from the 1911 Sullivan Act. This is how you lose your Second Amendment. So the 1919 case of Cynic takes away your First Amendment right. The 1911 Act of the Sullivan Act takes away your Second Amendment right. Well, you know what? Alexander Hamilton said, give me liberty or give me death. Meaning, I want my right to freedom to speech, to religion, to assemble, to petition, to the press, or my Second Amendment right to self-protection will be invoked. You see? Do you follow what I'm saying to you? Do you get it? These are the fundamental things that stripped away our basic natural rights, which are our natural rights to natural law. Do you see how everything goes back to the foundation of the Enlightenment thinkers that created our Bill of Rights? You have to understand the foundation of law, because then you'll never argue about the Kyle Rittenhouse case again. And I did a whole video on that, so I'm not going to go into it again. So the 1911 Sullivan Act, 1919 Cynic takes away your First Amendment. The 1911 Sullivan Act takes away your Second Amendment right. You follow? So your First and Second Amendment right are gone in 1911 and 1919. You don't have a right to say what you want to say anymore, or the government will arrest you, and the Supreme Court will uphold your conviction, which, by the way, later Charles Cynic is going to be pardoned by the governor, but he's going to sit in prison for a couple years just to teach him a lesson that you don't challenge the government. Sound familiar? Any auditors out there? You're not going to necessarily have to fight the charge, but we're going to take you to jail tonight for using your First Amendment right to film. But that's taken away now because of the Cynic case. Because if this case doesn't happen, Cynic versus United States, then your First Amendment right is never limited. And if you ever repeat, you can't stream fire in a busy movie theater, you're not for liberty, you're not for freedom, you're part of the problem. And if it doesn't make you upset, then you don't really love the country like I do. You don't have a gigantic flag up on your wall like I do. We're just not the same, that's all. There's nothing wrong with that. God bless you, go with God. But I really give a hoot about this country, and I think that we should try to get it back intellectually before the guns come out. Because when the guns come out, I leave. I'm gone. I haven't studied my entire life for some Neanderthal to shoot me. Over what? He doesn't understand the foundation of law. Okay. So now, as we go along here, we're going to get to the 1937 Marijuana Tax Act, but you're going to have Corrigan versus Buckley, which is going to be in 1926. So what's the foundation of natural law? What is it? Anybody? The three foundations of natural law. What are they? What are the three foundations? Life, liberty, property. You have life, liberty, property. Because as you know, most of your wealth in your family is going to come directly from your house. Well, Corrigan versus Buckley, what it says is it creates racial restrictive covenants, which then limit a certain population of black, brown, and Asian people where they can't buy your house. And that's going to cut them out of economic prosperity from 1926 until today. It's still going on today. And so you're going to lose your natural right to property in Corrigan versus Buckley of 1926. But there's even another case, the Marijuana Tax Act, which is going to do what? It's going to make sure that Standard Oil and that Harry Anslinger has a monopoly and creates the war on drugs today. The war on chemicals. So now these are gigantic, but I ran over Carroll here because I just got so excited. So in Carroll versus the United States, this is a prohibition law out of Oklahoma. And in Carroll versus the United States, what this is going to do, this case right here, just so you know, of this entire lecture now, and I'm coming up on an hour, so I don't want to take up all your time, but I'm coming up on an hour. Carroll versus the United States, this case right here, what this is going to do, Carroll versus the United States, is the most liberty-stripping police empowerment holding of the Supreme Court that there is on the books today. Terry versus Ohio overturned Terry. This is the law that Terry is based upon. The jurisprudence, the stare decisis, is based on Carroll versus the United States. Carroll versus the United States, of everything I've talked about tonight, Carroll versus the United States is the worst holding in U.S. history. The reason why we live in a police state today is because of Carroll versus the United States. In 1924, the Carrolls are running alcohol in Oklahoma, just like all the cops are. The cops are the biggest alcohol runners there are. And the FBI is going to be created in 1924, and Edgar J. Hoover is going to be appointed to the top of it, and Edgar J. Hoover is going to start to poison the alcohol barrels and the alcohol bottles because they can't stop alcohol because everybody wants to drink, and so they start to poison it, and when they start to poison the alcohol, that then sets up, so just put, it just makes me so upset. Let me put it into perspective for you so that you understand. J. Edgar Hoover is going to be appointed to the FBI in 1924. And what he's going to do is poison alcohol. His agents are going to go in and put cyanide in bottles. I'm not kidding. You can look it up. It's historical fact. He's going to poison alcohol bottles because the FBI can't get a hold of the alcohol rings because they're led by cops. They all have shortwave radios. They're ahead of the game. And so when he starts to poison alcohol, when Carroll versus the United States goes to court, when Carroll versus the United States goes to court in 1925, they then invoke the exigent circumstances clause. And this is the exigent circumstances clause. You notice on the big map here, on the gigantic poster, there's one little red square. And why do you think there's one little red square? How come there's one little red square on the giant poster? All of these iconic faces through history, all of these people have been legally departed. Here's the prison system line right here. Here's the civil rights heroes that fought for all of our rights. Here's the courts that ruined our lives. How come there's one little red square right here? Why did I put that there? Why did I add that even after I printed it out? Why did I do it? How come? Because the exigent circumstances clause is what creates the police state that we live in today. The 1925 case of Carroll versus the United States is what creates the police state, prison state we live in today. I always say overturn Terry. Truthfully, it's Carroll. Terry is based off Carroll. We don't have Terry without Carroll. Terry versus Ohio can't even live if we got rid of Carroll versus the United States. And specifically what it does, after J. Edgar Hoover is poisoning all the bottles of alcohol, they then say that alcohol's killing people. Of course it is. You poisoned it. You did this. You did this. The federal government did this. They're the ones who poisoned the alcohol. And so the exigent circumstances clause is going to be born. Exigent circumstances, meaning that they've been, just so you know, you can go into great study on the Carroll case. It is absolutely crazy when you go in and you actually dig into Carroll versus United States and you get into the case and you trace down history and you go to this link and that link and this link and that link. What you find is that the feds were trying to get the Carrolls for months. They had been chasing them in their car for months, trying to get the Carrolls and convict them of alcohol. Because, now why does this happen? Because of a mandate. I can go into that. I talk about it all the time. I don't want to bore you guys. But Carroll versus the United States, what this is going to do is create the exigent circumstances clause where the federal government, federal agents, Federal Bureau of Investigative Agents, or police can skip your rights. They can skip your Fifth Amendment right to remain silent. They can skip your Eighth Amendment right to cruel and unusual punishment. They can skip your Sixth Amendment right to face your accuser. They can skip your rights. They can skip your fundamental rights that are based on the philosophy of the Constitution and the Bill of Rights. And how can they do it? If the cops say that they're in fear that there's going to be a loss of life, if the cops say that they're in hot pursuit of you, or if the cops say that they need to seize the evidence out of your car because that alcohol could be poisoned because J. Edgar Hoover's poisoning it. The exigent circumstances clause is born because if you have a car with an engine and wheels on it, well, then you might be able to get away with evidence. And so we're going to skip your 6th Amendment right. We're going to skip your 8th Amendment right. We're going to skip your 5th Amendment right. We're going to skip your 4th Amendment right, the right to be secure in your person, houses, papers, and effects. The right for you to be secure in your person, houses, papers, and effects is going to be skipped. It's going to be completely skipped based on exigent circumstances. That because you're in a car, well, you being secure in your effects isn't as important as making sure we seize the evidence out of your car because J. Edgar Hoover is poisoning alcohol. And this is what creates the police state. If we can skip your Bill of Rights and say that there's exigent circumstances, well, then why do we have a Bill of Rights? Why do we have a list of rights that cannot be superseded, that cannot be revoked, that cannot be overran if we could just create the exigent circumstances clause and go around your rights? Why do we even have a Bill of Rights? Now, who determines if there's going to be a loss of life? The police. Who determines if they're in hot pursuit of you? The police. Who determines if they need to seize evidence out of your car? The police do. Who do the police work for? The police work for the government. We lose our rights. We create a police state, prison state with Carroll. I could do an entire lecture on Carroll. So I said it, right? I kind of got into it and I kind of pulled back a minute. They had been chasing the Carrolls around in their car for a few months, tracking these people, trying to catch them with alcohol. They wanted to get anybody they could. You got bonuses at cop shops. You got awards at the cop shop. You got a promotion at the cop shop if you caught someone running alcohol. And who were running the alcohol the most? The cops. So if the cops caught you, they would take your alcohol. It's just absurd. And so this Carroll case is how we have a police state, prison state today in the United States of America. Carroll versus the United States. If you don't know what the exigent circumstances clause is, welcome to knowledge. Now run it down, especially if you're a young person. Run down exigent circumstances clause. Run it down. Educate yourself. Come back and tell me things I don't know. I need you to take the ball. I've always said this since I started lecturing in June. This isn't about one man who created a stupid poster. This is about you learning this. This is about you taking the ball. This isn't about me. This is about us. This is about our freedoms. And it is not black versus white. It is elitist and government versus commoner. And if you're watching this video on Christmas, welcome to being a commoner. Me too. So the exigent circumstances clause, this is what creates the tyranny of which we live in today. This is what we live in today, is absolute tyranny because of the exigent circumstances clause. And so what's going to happen after here? Now we go into the big four cases. The big four cases are what? What are the big four cases? What are the four cases that you have to know? Carroll versus the United States, 1925. Brinegar versus the United States, 1949. Kerr versus California, 1963. Terry versus Ohio, 1968. The combination of those four cases create an absolute police state, prison state in the United States of America. Those four cases combined wipe away every single civil liberty that we have. And so Carroll is going to create what's called the Carroll Doctrine. Oh yeah, if we create a really fancy name for it and say something cute like the Carroll Doctrine, well then it makes more sense. It's the Carroll Doctrine that says we can supersede your rights if we just say that we're in hot pursuit of you. And of course they said they were in hot pursuit of the Carrolls for months. They were in hot pursuit of the Carrolls for months and months. No, you were just trying to get someone and get a crime on them is what you're trying to do. And so then, of course, as we jump from Carroll, we're going to go to the United States versus Miller, which I touched on earlier. The United States versus Miller is what's going to... So you got the 1934 National Firearms Act, but it's actually going to be upheld with the 1939 case of the United States versus Miller. And the 1934 National Firearms Act is based on the 1929 St. Valentine's Day Massacre that's pulled off by who? By police. Now, you can read in history how it was the Al Capone gang versus the Lucky Luciano gang and how they went in police uniforms and they just executed a bunch of other alcohol gang members. And then they're going to say that they were wearing police uniforms. And then you know what they try to do? They try to ban shotguns. Sound familiar? Sound familiar? They try to ban shotguns. I swear to God, I'm not kidding. The shotgun is going to be banned because they used a shotgun to mow down a dozen or 2 dozen other alcohol gang members. And so where did they get those police uniforms they were wearing? I mean, if you haven't scanned the 1931 Wickersham Commission from, I believe his name is George Wickersham, I hope that's correct, the Wickersham Commission, and what this is going to say is that police are the biggest alcohol runners in America, and it's not even close. You can't read the entire Wickersham Commission because it would be like reading 4 volumes of War and Peace. It is so deep and so vast that there are, let me make sure, I don't want to say anything incorrect because being wrong is always wrong. There are several volumes of the Wickersham Commission. It comes out, there's so many volumes of the Wickersham Commission that the volumes come out in 1931 and 1932. The study begins in 1928, 1929, 1930, 1931, 1932. 5 years. And the Wickersham Commission says that police are the alcohol runners. You think Al Capone's gang is famous? The police were more famous. And so this is gonna solidify that we're gonna have gun laws in America that are gonna fundamentally strip your Second Amendment right. In California, when the pandemic hit, I tried to go buy bullets for my gun, and I couldn't buy bullets because I wasn't in the California state system. Where does the Second Amendment say I gotta be in a system to buy bullets? Where does it say that? I thought the Second Amendment says that my Second Amendment right shall not be infringed. I thought that's what it said. Am I mistaken about that? Am I mistaken? So, you lose your First Amendment right with 1919. You lose your Second Amendment right with the 1911 Sullivan Act. Carroll versus the United States is going to give the police a reason to go around your rights, and all they have to say is there is a fear of loss of life, they're in hot pursuit, or they need to seize evidence off of you, and I will touch on it anyway, and that's based on the 1920 mandate that started from the Temperance Society. The Temperance Society begins in 1820, and final galvanizes in 1920 when women get the right to vote with the 19th Amendment in 1920. They then make alcohol illegal with the 18th Amendment. So it's almost like a gimme and a punishment at the same time. Women are going to get the right to vote, and at the same time we're going to prohibit alcohol. That lasts for 3 years. 1 out of 6 Americans, because of a mandate, will be shot, imprisoned, or killed. I believe the statistics is hurt, imprisoned, or killed. Those are the stats. 1 out of 6 Americans based on a mandate of prohibition. And so now the 1934 National Firearms Act is going to be based on the 1929 case of the St. Valentine's Day Massacre, and then U.S. United States versus Miller is going to uphold that you can ban guns in America. You have to create gun laws in America. It's going to uphold this. So now you've lost your First Amendment right to speech, you've lost your Second Amendment right, you've lost your Fourth Amendment right with the Carroll Doctrine. The Carroll Doctrine, let's not call it that. Let's call it the Carroll Tyrannical. Let's call it the tyrannical Carroll case. Let's call it the tyrannical Carroll case. Let's get rid of the Carroll Doctrine. It's the tyrannical Carroll case. And that's what's going to fundamentally strip us of all our liberties, the tyrannical Carroll case. So then as you come forward here, then the 1949 case of Brinegar versus the United States, this is where they really give cops power. The Brinegar case, oh man, ooh, it'll make you sick. It's in my ebook. It's available on Delete Laws, but I'll tell you what it says. The Brinegar case, the holding by the Supreme Court, 1949, that's going to be the Vincent Court up here. This case up here in 1949. What they're going to write here in the Brinegar case is they're going to say, because they're trying to get Brinegar for horse betting. They're trying to get him for lottery tickets or horse tickets. And so when they go to the Brinegar's house, they follow him to his house. Now they're following him in his car, but he gets out of his car, Brinegar does, and goes into his house. And so now the tyrannical Carroll case cannot be invoked because Brinegar is no longer in his car. You see the jump from Carroll to Brinegar? This is important that you put this together. The jump from Carroll to Brinegar is they created the exigent circumstances clause based on if they need to seize evidence out of your car because your car can roll away, but Brinegar gets out of the car and goes into his house. So now you can't invoke the exigent circumstances clause because Brinegar's not in his car. And so what they do is they walk up and they walk right into Brinegar's house. And the Brinegar case is going to create a total police state. It's going to get worse in Kerr. But here's what Brinegar says. The Brinegar case says that if a cop, a man of reasonable caution, has reasonably trustworthy information that there could be crime afoot, that he can enter into your domicile. So Carroll makes it so that your car can be violated, but then Brinegar makes it so that you can't be secure in your house anymore, completely invalidating the Fourth Amendment in entirety. You no longer have a right to be secure in your home. Because when Brinegar gets to his house and walks in the house, they know that he's got the lottery tickets, but they can't get his car because he got out of the car. So they just walk into his house, they find the tickets, and they arrest him. They find the lottery stubs in his garage. And so when it gets to the Supreme Court says if a man of reasonable caution has reasonably trustworthy information, a man of reasonable caution, I'm not sure if you know this or not, but when police are first formed, they're the degradants, they're the degenerates. They're the people who get in trouble for being drunk at work, and they then have to do night watch duty. It's the same thing today, the same cops today, the exact same thing. So now Brinegar says that if a man of reasonable caution has reasonably trustworthy information, he can just walk into your house. Well, who's the man of reasonable caution? It's some Neanderthal who has no other skills. He has no other skills. If you saw my last audit that I put on YouTube a couple of days ago, I literally tell the guy, you have no skills. You don't have any skills at all. You're not educated enough to teach anything. You can't be a producer, a writer, a plumber, a woodworker. You have no skills. And that's never changed in policing, not once ever. As long as you're willing to follow orders, wear a badge, and hurt people, and take them to the dungeon as you say ridiculously stupid things, like, I have a right to go home safe to my family, as you're dropping a human being off at a dungeon, and the monsters behind that wall are even worse than the monster that you are. They have no skills. That's why they're a guard. They can't even get a job as a cop. Brinegar makes it so that cops can just, if they have reasonably trustworthy information, and if he's a man of reasonable caution, they can just walk into your house. It gets worse in Kerr. Kerr versus California in 1963 is where they're chasing the Kerrs in the same thing. They're in their car, and they're chasing Diana Kerr and I forget his first name, but they're chasing the Kerrs. It's a couple. And back in 1963, they're called narcotics dealers. They're called narcotics dealers. So the Kerrs are marijuana dealers in 1962, I believe. However, at the 1961 Single Convention on Narcotic Drugs, the Single Convention on Narcotic Drugs hosted in Manhattan, by who? By who? By Harry Anslinger. Harry Anslinger, who's married Andrew Mellon's daughter, who invested in who? William Randolph Hearst and Lamont DuPont. And these guys, what they have a vested interest in is making sure that the hemp business doesn't have any success. And so the 1937 Marijuana Tax Act is passed in May or June of 1937. And at this time, Harry Anslinger has married Andrew Mellon's daughter. He dies in October. And so then the 1937 Marijuana Tax Act, that protects the investment that Andrew Mellon had made in Lamont DuPont and William Randolph Hearst. And now Harry Anslinger is heir to the Mellon throne. He died with $19 million and he was a career cop. Why? Because he had the heir of Andrew Mellon. So when he hosts the Single Convention on Narcotic Drugs in 1961, he hosts that in Manhattan. Who does he invite? He invites his friends from World War I. Where was he stationed? At The Hague in the Netherlands. Well, who is his buddies at The Hague? The World Health Organization. I'm giving you guys a master's course in history here. This is a master's course. This is 20 years of researching. Harry Anslinger hosts the Single Convention on Narcotic Drugs, and he invites his buddies that he met, called the World Health Organization, when he was stationed at the Netherlands over World War I. Harry Anslinger, you may not know it, he was a double agent for the United States. He spoke both German and he spoke 3 languages. Harry Anslinger was incredibly intelligent. Now, you may hear about Harry Anslinger was racist and how he hated black people. He loved money. He loved money. And so when he inherited Andrew Mellon's throne at the Single Convention on Narcotics Drugs, what does the World Health Organization say at this Single Convention on Narcotic Drugs? And why do they uphold the Kerr case of 1963? Why? Because the World Health Organization comes in and they back up all the propaganda that Harry Anslinger has spewed that said that marijuana will turn your kid into a psychopathic axe murderer. They make a movie about it. And so at the Single Convention on Narcotics Drugs, Harry Anslinger's buddies come in and they back up everything Harry's been saying. One puff will make you go crazy. One puff will turn your wife into I want the kids to watch it. One puff will turn your wife into someone who would be promiscuous on you. One puff and it'll make white women want to sleep with black guys. And that's backed up. Matter of fact, at the Single Convention on Narcotic Drugs, the World Health Organization says that every single marijuana plant in the world should be eradicated within 25 years. That would have been 1985. That's when the CIA is dropping off crack to Rick Ross and planting gun barrels all over South Central LA so that they can arm people. That's another story. So now at the Single Convention on Narcotic Drugs, the World Health Organization, along with who? The FDA. They come in and say that marijuana will create an axe murderer out of your kid. It'll make a prostitute out of your wife. It'll destroy your marriage. It'll destroy your children. And so 61, this is said. So then in Kerr versus California, 1963, when the police are chasing Diana Kerr and they get to her house and she leaves her car, so you can't invoke the exigent circumstances clause where your car can roll away, so they got to seize the evidence. They just walk right into the Kerr's house and they're empowered. Why? Because the World Health Organization has said that marijuana is the demon drug. This is debunked in the 1944 LaGuardia report, which I have on my website. I give it away for free. It's not my property, so it's yours for free if you want to read the LaGuardia report. It's 80-year-old information, very valid today. So now the Kerr case, what exactly is the Kerr case going to say? And so now remember, Brinegar extends into Kerr. The case precedent, the stare decisis Kerr, is based off of Brinegar. And what exactly does that say? It says that if a man of reasonable caution believes that there's crime afoot in your home, it can circumvent your Fourth Amendment rights. And so Kerr versus California then creates the knock and announce rule for police. That's what happened to me in 2002. The cops knocked on my door, announced that they were there, but I was in the bathtub. And once they knock and announce, and what they do is they go knock, 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 police, police, police. And then they just, boom, kick your door down. And so Kerr versus California says, as an extension of Brinegar, that if the cops believe there's a crime afoot, all they have to do is knock and announce. That's why you see on all the TV shows when they just knock and go, police, police, and then 5, 4, 3, 2, boom, in through the door. It used to be 30 seconds or 45 seconds or a minute, whatever the Kerr holding says, but cops don't do that. They just knock on your door and kick the door down. And that's Kerr. That's Kerr. So now you got Carroll, you got Brinegar, you got Kerr. This is the knock and announce rule. This is where if they're standing outside your house and think there's a crime. This is if in your car. Anybody ever had their car searched before? It's because of Carroll. So now up here, we're going to extend. What is the stare decisis? What is the case precedent for Terry versus Ohio? I'll give you a guess. It's right here. Kerr versus California. Kerr versus California is an extension of what? Carroll versus the United States. Carroll versus the United States creates the exigent circumstances clause that if the police believe there's going to be a loss of life, if they think there's going to be a loss of life, well, then your rights can be circumvented. Based on prohibition, based on J. Edgar Hoover poisoning alcohol, based on them chasing the Carrolls around for 3 months. And so when John Terry is standing downtown Cleveland in 1963, the same year the Kerr case is held, Martin McFadden sees him and he says, you know what? I feel like there's going to be a loss of life here. I'm going to invoke the Carroll doctrine that there's exigent circumstances, and I'm going to run up and grab John Terry. And I'm going to say that I'm afraid that he's armed and dangerous. Well, just so you know, John Terry is mentally ill. He'll spend the rest of his life in an insane asylum. However, Childress, Katz, and Terry, for the rest of their lives, all said, we were never going to rob a jewelry store. That's a lie. And by the way, Martin McFadden never said he was in fear for his life, ever. It was Euclid Street. I made a video about it. It's on this page. If you guys have not seen, part 1 of Overturn Terry, part 2 of Overturn Terry, or part 3 of Overturn Terry, you clearly see that it's a total ruse. It's totally bullshit. What happens after Terry versus Ohio? There's the prison line. There's the prison line. You see the prison line back here? There's the prison line right there. There's Terry versus Ohio. That's what happens to prison after Terry versus Ohio. That's what happens after Terry versus Ohio. We lock up 8 million people since Terry versus Ohio. There's the stick. Hey, look, I'm not a genius. Neither are you. None of us are Einstein. You don't got to be a genius. There's Terry versus Ohio right there. There's the prison system after Terry. We lock up 8 million people. There's still 2 million people, 2.5 million people in prison today because of Terry versus Ohio, which is because of Carroll versus the United States, which is because of Brinegar, which is because of Kerr, which is because of the Harry Anslinger creating the war on drugs, using marijuana as a guise for capitalism so he can make the most money possible. Making sure that he protected Lamont DuPont's investment, William Randolph Hearst's newspaper business, and J.D. Rockefeller, the chairman of the board of Standard Oil that was broke up in 1911. The 1914 Harrison Act ensured that they would put cannabis on the banned substances list. And then the 1924 League of Nations, I can go into great detail here, but I want to get lost. Terry versus Ohio now will create this standard that if a police officer is suspicious of you, as Martin McFadden was suspicious of John Terry, he can run up and grab you. This is why auditors get arrested right here because of Terry versus Ohio. If you're a police auditor, the reason you get arrested like that is because the cop can say, oh, I feel like you're armed and dangerous, leading to detainment. Detainment from the Supreme Court was supposed to mean a light pat down and a small little area of detainment where they could talk to you. Police create police policy based on Terry versus Ohio. If you guys watch my last audit, you'll hear me say to the cop, he goes, this is for your safety? Right, it's for your safety. And he says, this is my stop. I say, no, this is my freedom, bud. Because Terry versus Ohio fundamentally strips our freedom. You're no longer free. All the cop has to say is, I was afraid he was armed. And who's armed? All of us. You're armed, I'm armed, we're all armed now. Imagine if I had been carrying out of fear for my life. Because I have a right to life, according to John Locke's theory of natural law, I have a right to life like everybody else does. So Terry versus Ohio is going to fundamentally strip away your entire Fourth Amendment. It's gone. Your entire Fourth Amendment is gone. Your entire Fourth Amendment is gone here. To be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Gone. You might as well just take a pin and just scratch it right off. It's gone. It no longer exists. It's gone. And no warrant shall issue but upon probable cause, supported by oath or affirmation of the victim. Terry versus Ohio makes it so the cop can say, I swear I was suspicious of him. That's what Terry versus Ohio does. How far away from that is it, and no warrant shall issue but upon probable cause, supported by oath or affirmation? This is where a law has been broken, and then a warrant can be issued, and it's backed up by the victim, swearing an oath that you created a victim out of them. And the best example I give, you go back to the Fourth Amendment in 1776, and you have kicked my dog, raped my sister, and burned down my house. I went down to the police bureau, I filled out an oath that you have broken the law and created a victim out of me. And I can prove it. Here's my sister. Terry versus Ohio makes it so that any cop can say, I swear I was suspicious. And that's all they need. One cop. William O. Douglas, who I talked about in the beginning of this lecture, he says, we're taking a road to tyranny. What's the exact words he says? I used to have his dissertation memorized, but he said, we're taking the long road to tyranny or something like that. And we're giving the same power to police on the street that we do a magistrate. And what are police? Police are guys who don't have any skills. If you're a cop and you're watching this, why would you want to be a cop? Unless you couldn't do anything else. Terry versus Ohio is the fundamental linchpin of the prison system and the death state of police today, because all they have to say is, I was in fear for my life. I was in fear for my life. That's all they have to say. Now, you could also throw Graham versus Connor in here, the 1989 Graham versus Connor, that gives police the right to shoot you if they say they're in fear for their life. And so that's where that's going to come from, okay? Anyway, I've been on for 90 minutes. I always said I wouldn't go more than an hour. Sometimes I get excited. Sometimes I get a little long in the tooth. Forgive me. Just so you know, I believe that this is the first live cast I've ever done where I did not say one single curse word. Not one. And I'm not going to curse anymore so that you can show your kids. You can show your kids. So I'm going to touch on Graham versus Connor before I get out of here. Now, Graham versus Connor is the same wording as Brinegar versus the United States. It's the exact same wording. Brinegar versus the United States says that if a man of reasonable caution believes there's crime afoot in your house, well, he can just walk right into your house. Graham versus Connor says that if the cops see you and they believe in their mind of what you've done before you got here, so if a cop creates a story in his head that you just killed your mother and your sister and stuffed them in a closet, and he says, hey, look, I thought the guy was a killer. Use of force will be determined by the reasonable officer on the scene. That's what Graham versus Connor says. And that's the final one that I'm going to go over today. I would be remiss not to tell you about Johnson versus Glick. If you are put in jail or in the dungeon, you don't have a right to file a 1983, which is a civil rights violation because of Johnson versus Glick. So if you ever get put in the cage, you unfortunately have to become a different person. I have to become a beta male very quickly because I don't want to get killed. And they'll kill you. You're talking about Neanderthals in there. So Terry versus Ohio is going to create it where you lose your Fourth Amendment standard completely and utterly from top to bottom. And this is why my shirt says Overturn Terry. This is why I made this poster. This is why I came out of the darkness. This is why you haven't heard about me until June of 2021, because I finally got to a point after Breonna Taylor was no-knock raided and murdered, I was no-knock raided. And I finally said, oh my God, somebody has to say something. Somebody has to actually explain the foundation of law and how we got to Terry versus Ohio, which, by the way, Wilson versus Arkansas is how Breonna Taylor. Wilson versus Arkansas is an extension of Terry versus Ohio, which is an extension of Kerr versus California. Wilson versus Arkansas says the exact same Kerr versus California, that says cops cannot no-knock raid your home unless it's in the name of officer safety. All of these Supreme Court cases stem off of Terry. I'll save them for another lecture that's not on Christmas, so I'll let you guys go. But we're going to go into Terry on the next lecture. We'll go into Terry on the next lecture. If you guys have any questions at all, please don't hesitate to email me or contact me. I do have a website, Delete Laws. That's my website. You can get a copy of my poster, a digital poster on Delete Laws. You can get a copy of my digital poster, or you can get a hard copy poster on deletelaws.com, on deletelaws.com, right there, if you guys want to get a copy of my poster. I used to do a cup of coffee fund. If you want to take a screenshot, that's great. I appreciate it. It's Christmas time, so everybody's pretty busted. I understand that. So, anyway, oops, sorry about that, a little too close. Any questions? Any questions? Do I have any questions? I'll be happy to answer a question for a moment or two. I'm going to drink some water, eat some pie, and then try to calm down because this always gets me excited. This always gets me excited. Thanks, Dr. Sean. I appreciate it. All right, guys, listen, I'll get out of here. Thank you very much for your time. I appreciate it. I enjoy the time I get to share. I enjoy the time I get to educate other people. And please take your time and listen to or read The Spirit of Laws. Listen to or read the Federalist Papers, the Anti-Federalist Papers, or Leviathan by Thomas Hobbes, or make sure you read Harriet Beecher Stowe's book, Uncle Tom's Cabin, so you understand how we got to this place. Dr. Vegetable, I saw you. I followed you back on Instagram. If you guys don't know, I was recently deplatformed, so my 300,000 followers on TikTok were wiped away, and that's by some members of the Black community within BLM, some members in a cult called The Fold, which I am taking them to court. You guys can look at my website, brandedaracist.com. I am doing a fundraiser so I can sue these people in federal district court, and I'm going to get that done. But anyway, appreciate you guys. Thank you so much for tuning in tonight. I had a great time with you. Merry Christmas, happy holidays. Do me a favor, try to love each other, try to be nice to each other, and share this video with children so that they understand you got the ball. You got the ball. Take us to the promised land, all right? All right, I'll get out of here. You guys, thanks a lot. Appreciate your time, and God bless.